Welcome and thank you for joining Seyfarth's webinar, Commission and Incentive Compensation Plans after Reuter, Batten down the hatches. Excuse me. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Following the webinar, there will be a 15-minute office hours segment where attendees who stay connected can interact with our panel in an extended Q&A format. Copies of the webinar recording materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Patrick Bannon. Patrick, you may begin.
And then thank you everybody for joining. I'll start with my own disclaimer that we don't write these laws and we don't issue these Supreme Judicial Court decisions. I'm pleased to be joined today by my colleagues Barry Miller and Molly Mooney. Barry is a litigator in our labor and employment group, in our wage and hour group, and he litigates regularly in state and federal court regarding incentive plans and other wage and hour issues, and he helps employers design incentive plans to try to not need litigation. Molly is likewise a litigator in our wage and hour group, and she likewise spends a substantial amount of her time litigating wage and hour cases, including cases involving incentive compensation. So I will turn things over to Molly, and then I'll come back in, and then you'll hear from Barry, but we'll start with Molly. So over to you, Molly.
Great, thanks so much, Patrick. And we can go to the next slide. Great, so we've laid out an agenda here for today's program, and we're all here today to discuss incentive plans and commission plans and how the SJC's recent decision in Reuter versus the city of Methuen will have an impact on those things moving forward. So we'll go to the next slide. And before we jump into the substance of today's program, I'm going to give just a brief overview of the decision that got us here. So the Supreme Judicial Court issued its decision in Reuter versus city of Methuen in early April. And by way of background, in that case, Beth Reuter, the plaintiff, worked as a custodian in the city of Methuen school system, and the city fired her after she was convicted of larceny. And at the time of her termination, she had a not insignificant amount of vacation time that had accrued, and the city did not pay out her vacation time as required by the Wage Act. So it paid out that vacation time about 3 weeks late. Months later, Ms. Reuter sent a demand letter to the city asking for triple damages on that late paid vacation. Now, at the time, neither party disputed that the city had violated the Wage Act when it paid her vacation late, but they did dispute what the proper measure of damages should be. So prior to the SJC's Reuter decision, there was longstanding precedent in Massachusetts that where wages are paid late, but before a plaintiff files a complaint, the only damages are interest on the delayed payment. And that's what the city of Methuen ultimately paid Ms. Reuter after receiving her demand letter. She, however, insisted that her damages should have been triple the late payment because the Wage Act authorizes triple damages for Wage Act violations. So she filed a lawsuit and it went to a bench trial. And the trial court in that case agreed with the city of Methuen. They found that it did in fact violate the Wage Act, but that the only damages available to Ms. Reuter were interest on the delayed payment and attorney's fees. So the trial court's decision was ultimately appealed and it went to the SJC. We can go to the next slide. So in the Reuter decision, the SJC completely changed course on what the precedent in Massachusetts had been. And it held that any Wage Act violation, even a minor violation where the wages are paid a single day late, results in triple damages. And in the court's view, allowing payment of owed wages to be a defense to triple damages would essentially authorize and, in the court's view, even encourage late payments right up until the filing of a complaint. And the court reasoned that that really goes against the entire purpose of the Wage Act, which is to prevent the detention of wages. So it's an unfortunate decision, but it's sort of what we're working with now. And under this new standard, there's really no wiggle room for mistakes. So we're operating in a world now where any single Wage Act violation will automatically trigger triple damages. So whereas before, if you paid wages a day or two late, or you had a minor violation that was remedied, you could avoid triple damage liability as long as those wages were paid prior to that employee filing a complaint. And now that option is entirely off the table. So at the end of the day, the Reuter decision suggests there's really no defense available anymore for the late payment of wages. And internally here, we've been analyzing potential defenses, and ultimately there may be potentially a due process argument, but we'll have to see how that plays out as cases begin to be litigated under this new standard. Next slide, please. So we're here today to talk about how the Reuter decision could impact incentive compensation and what you can do to limit your potential exposure. So generally, we have seen an increase in claims alleging unpaid incentive compensation, and oftentimes those cases include a Wage Act claim, but they usually also have a breach of contract claim based on the incentive plan itself. And the problem with these cases is that they often involve larger sums of money than, a typical late paycheck case. So the potential liability in these cases can get very high. It's not uncommon to see liability in the high six figures, even seven figures, for, larger commissions or incentive payments. So in this new world under Reuter, where we're operating in an environment with essentially zero tolerance for mistakes, it's going to be really important for employers moving forward to take a deep dive into their incentive plans to ensure that there is no room for ambiguity with respect to what people are owed and how those payments are going to be made and when those payments are going to be made. So ultimately, what we want to do is eliminate any opportunity for employees to say they were paid late or that they were not paid what they were owed. So Patrick is going to briefly discuss what types of compensation are considered wages for our purposes, and then we'll dive into specifically what you can do, hopefully to help improve your incentive plans in light of Reuter. So before I pass it over to Patrick, we are going to announce the CLE code for this program. So the CLE code is SS2732. That's SS2732, and I'll hand it over to Patrick.
Thank you, Molly. So you've just heard the consequences and how severe they can be if you get on the wrong side of a claim that you didn't pay wages on time. Those consequences stem from the Massachusetts Wage Act, and the Wage Act protects wages. So the threshold question, as you try to figure out whether you have exposure or you're in danger under the Wage Act, is to figure out whether the compensation at issue is considered wages. So I'll start with sort of the basic, easy part of what counts as wages. The Wage Act is probably, I get the impression from the attendance list, this is a sophisticated group of people on the call. You're all, I'm sure, familiar with the Wage Act. But in case you're not, it's a very old law. It's very hard to read, and it's not user-friendly in any way. So obviously, in keeping with that, it doesn't define the key term in the statute. There's no definition of wages in the Wage Act, even though you get triple damages in attorney's fees if you don't pay wages. We don't know exactly what wages are, but we do know some things about the contour of wages from case law and common sense, and from reading other parts of the statute. Obviously, it includes what anyone would think of as wages: hourly pay for an hourly employee, weekly salary for a salaried employee. If you have employees who are earning tip credits, tipped employees, the tip credit or service credit counts as wages. As is clear from the Reuter case itself, vacation pay is wages. That battle has been fought and lost by employers pretty much straight down the line, and vacation pay now is going to be counted as wages all the time, or virtually all the time. And holiday pay is also wages. So a mistake as to any of those types of compensation gets you into this triple damages and attorney's fees realm. There are some types of compensation that are excluded from the Wage Act. it doesn't cover everything. The basic idea behind the Wage Act is to prevent employers from getting employees to work hard and do things that the employer wants them to do with the promise of getting some compensation and then withholding the compensation or delaying the compensation. So with that basic idea behind in mind, we can see why some of these other types of compensation might be excluded. So severance pay is excluded, and we put probably in the slide because we've seen surprises in this area of law. There's an appeals court case called Brzezinski, which has been around for, I don't know, 15, 20 years, that says that severance pay isn't wages, because severance pay is paying you out for a release of claims and making your life easier after you're let go, but it's not something you've earned along the way, so it's not wages. There are a couple of cases, I think at least one, maybe two Superior Court cases that have questioned Brzezinski and not followed it, but the weight of authority is still strongly in favor of the view that severance pay is not wages. Deductions from pay for the purchase of stock, a little bit of a niche, but there's a case on point that says specifically that that is not wages. Of course, the deductions have to be authorized. Contributions to deferred compensation plans are not wages. There's a special statute that allows employers to do that and have them not be wages. And health insurance premiums are not wages. So that's sort of the big picture. There are many ways that employers, just following their regular practice in ways that they've done for years, could run afoul of the Wage Act by not paying the second that something is due. And as Molly pointed out, any delay is as bad as no payment at all. You'll be on the hook for triple damages. If you'd like to hear more about sort of the ways that run-of-the-mill wage payments can cause problems, there's an earlier webinar that Barry and Molly did that I'm sure we have recorded, and you could listen to that one. But our focus today, as I think you all know, is going to be on two specific kinds of wages which have the potential to be the biggest dollar issues. So if we go to the next slide, please. One is commissions, and the other is bonuses / incentive plans of other sorts. So I want to spend a minute on commissions and then a few minutes on bonus / incentive plans, and then Molly and I and then Barry will talk about some practical steps that people can take to try to steer out of trouble. Okay, so commissions as wages. I wish we were live so that I could get a sense of whether everyone was ready to move on and listening intently, but I will pause slightly to signal a transition to this new topic and hope everyone is still awake. Commissions are, by explicit text of the Wage Act, treated as wages. And the key sentence says that commissions, that the Wage Act applies so far as apt to the payment of commissions when the amount of such commissions has been definitely determined and has become due and payable. That's sort of the magic language. The basic rule about commissions is that they are going to be treated as wages, and they're going to be required to be paid out within the time period that you're allowed to, that you're required to pay out wages. But commissions are obviously trickier than regular wages for a couple of different reasons. It's not always clear when a commission is earned, and then it's also not always clear when a commission is due. And so here, I think what makes this issue especially hard, and I think judges find this issue hard, and it makes it really hard to predict the outcome of court cases, is that the Wage Act really is schizophrenic. Commissions are almost always a creature of contract, or at least, some kind of written understanding between the employer and the employee. But the Wage Act is a statute that is sort of anti-contractual. It says, employers, we don't trust you to make special deals with your employees about when they'll get paid. We want them to get paid within this time period, no matter what, and no tricks. That's essentially what the Wage Act is saying. So when judges look at commissions, they have to decide, well, should I look at what the commission policy or commission plan says, or should I say, no, the employee has earned this commission, and so it's due under the Wage Act? And different judges come out different ways, depending on the facts of the case, and it makes it really hard to predict. But to me, the factors that someone should look at to determine whether a commission is earned under the Wage Act are primarily as follows. If the employee has done everything that the employee needs to do to close the transaction that is the basis for the commission, there's a good chance that a judge is going to say the commission is earned. So let's take an example. Let's say you have a policy that says that employees earn commissions on a certain type of sale at a certain percentage. But then it also says that the employee has to be employed through the date that the commission is paid, which will be 6 months later. A judge looking at that, so the employee goes out and works hard and brings in the sale and it closes, and then by the commission plan, they're going to be entitled to 3% of that sale, but it's not due for 6 months and they have to stay employed. And then the employee leaves. A judge looking at that is probably going to ask, did the employee do everything the employee was supposed to do to close the sale? And did the company get what the company wanted out of the employee? And the answer is going to be yes. And the judge is probably going to say that commission has been earned. We don't know for sure. There's no SJC case on that point. There's mostly just trial court cases. But that seems to be a situation where judges are going to take the paternalistic side of the Wage Act and say, you told this employee, go out and work, and bring in a transaction like this. And if you do, we'll give you this much money. And the employee did it. You had the thing about them continuing to be employed, but why should that matter? So it's earned and it's a wage. So the second factor that I think judges will look at is whether the transaction will occur. In the example I just gave, the transaction did occur. The sale closed and the employer brought in the money. So that's another reason why the court is likely to find the commission to have been earned. But if the sale hasn't closed yet, if the employee has just worked hard to bring in the sale, but it's a long-term sales process and it hasn't closed yet, and the employee leaves and someone else has to take it over and finish closing the sale, then I think the employer has a much better argument that the commission hasn't been earned. But the flip side is, if the sale has been closed and you're just waiting for the money to come in, and the employer's done everything that the employee's done everything the employee can do, and you're just waiting for the money to come in, then a judge is going to see that as a reason to treat the commission as earned. And so finally, it's just unclear whether the employer can impose other contingencies. And Molly and Barry will both speak to this when we get to the practical steps that you can consider taking. But it's unclear whether you can have other contingencies, such as the employee needs to remain employed through the end of the quarter, or through April of the following year, or you have to wait 60 days to see if there are any returns or requests for rebates or refunds. Those are the status of provisions like that is unclear. And we're working under a statute that has triple damages and attorney's fees. So we can't predict how a judge is going to treat contingencies like that, which is probably not good for the party that could face triple damages. So that's a little discussion about when commissions are earned. And if people have questions about that, throw them into the chat and or stay on afterwards, because Molly and Barry and I would rather speak about almost nothing else than these issues. And then another question is, when is the earned commission? Let's say it's earned. Is it due and payable? Sometimes it's easy to determine the amount. It's definitely determined in due and payable. If the plan says it's 3% of the sale's made, the amount. So now it's certainly determined. And then if they say it'll be paid 6 days after the sale, then it's due and payable. Sometimes, though, it's not easy to determine the amount of a commission, because if a commission plan is complex, the percentage that you get on one sale might depend on how many other sales you make, or on how many sales your whole group makes, or on the company's performance for the quarter, or other factors that are just not known yet. So in that case, even though the employee has done everything the employee needs to do, you still can't determine the amount of the commission until some additional information comes in the future. And in that case, it's not yet definitely determined. I'll throw out a hard question. What if you know that it's going to be at least X dollars, and it could go up to some higher amount depending on what happens next? Would a court say that X dollars has been definitely determined and is now potentially due and payable, or would the court let you wait until you know the exact amount. That I think is also an untested proposition. Then whether a commission is due and payable goes back to the question of other contingencies. There are very few companies that have commission plans that pay commissions weekly or even biweekly. It's monthly or quarterly is a lot more common. So if you have a commission plan where someone does everything they need to do, closes a sale, the amount is known, you can figure out exactly to the dollar how much they're going to get from that sale, but you just don't true up your commission plans until the end of the quarter, and you don't pay them out until 30 days after the end of the quarter. We've got a question there about whether that commission was due and payable before the end of the quarter. And so that's something that people will want to look at and think about whether there's an alternative and is there some way to trim their sales and reduce their risk. Okay, so that's commissions, and we have a lot to cover here, so I'll try to keep moving to the next slide, and we'll try to be a little bit more concise about bonuses. And I'm using bonuses now to mean any other incentive compensation plan. It could be called incentive compensation, it could be called profit sharing, but I'm calling it a bonus just for simplicity. So whether a bonus counts as wages is also, under the Wage Act, is also a difficult question. Some things we know. You can't make something a bonus and say it's outside the Wage Act just by calling it a bonus. Courts will certainly look hard at whether it's really a commission. And a commission doesn't have to be a classic sales commission. A commission is any payment to an agent that's based on some work that the agent does that results in some revenue to the company. So there are cases out there that say, no, your bonus is really a commission, or certainly that it's a lot like a commission, and so we're going to treat it as covered by the Wage Act. We also know that a truly discretionary bonus is not covered by the Wage Act. If at the end of the year the owner just gets overwhelmed by a fit of generosity and just decides to give every employee $1,000, they had no idea it was coming, just shows up in their paycheck, that's a pure discretionary bonus, and it's not covered by the Wage Act. But again, you can't just declare your bonuses to be discretionary by adding the word discretionary in front of each pay code in your accounting system, or just calling it a discretionary bonus. It has to really be discretionary, and that's not easy to maintain. If every employee in the company knows darn well that they've always gotten a bonus in this position, every one of their peers has always gotten a bonus in this position, sometimes they can even calculate the amount of the bonus that they're expecting. Just preserving the technical right to, well, maybe this year we'll change our minds, or maybe this year we'll vary the amount. I don't know whether that would be enough for a court to say that it's still discretionary. I think there's certainly some risk there. So whether a bonus is discretionary has to be looked at in a hard-headed way, and not sort of calling all the pitches as strikes because you want them to be strikes. But let's say you have a bonus that is non-discretionary, but it's subject to a contingency. So let's say that you've told the employee what they have to do to get it, and you've told them what the amount would be, at least within some range, and so you're worried that it might be under the Wage Act. But could the employer say, well, you can't get the bonus unless you stay through the bonus payment date? So it's an annual bonus, let's say, and you don't get it unless it gets paid out in March, and you don't get it until you stay through March, unless you stay through March 31. That's really common for employers to do that. And unfortunately, it's untested whether you're allowed to say that. The Wage Act, as this is where the schizophrenia comes in. The employer has made a deal with the employee to pay for the bonus, and has said, this is the deal. The bonus has to be is only paid out if you stay through the payment date. But on the other hand, the Wage Act is this protectionist statute that says don't cheat someone out of money that they've worked all year to earn. So whether that stay through the payout date, which is really common, will be respected, or that whether it will be seen as a way to evade liability under the Wage Act remains to be seen. The equation may change a little bit if your bonus is expressly and in reality intended as a retention device. If the whole point of the bonus is to get everyone to stay through some period of time when you need everyone to stay through, then I think most judges probably wouldn't require you to pay it out to people who left before the retention date. So if the purpose of making them stay through the bonus payout date is expressly and in reality to make sure that you retain them as employees through at least that date, that strengthens your argument that that the bonus hasn't been earned because one of the conditions of getting the bonus hasn't been met. And that's really redundant of, I think I covered the last 2 bullet points both at once, whether you can define the due date, whether you can add additional contingencies. So there's a lot of case law on what counts as a bonus, but not very much at the SJC level. There's some, but we still don't know for sure how a particular case is going to grab a particular judge, which is a dangerous place to be under a statute like this. So I will pause there for a second, and then we'll move to the next slide, and Molly and I will talk a little bit about how employers can look at their incentive compensation plans in general, and then Barry will have some more specific thoughts and suggestions about commission plans and so that's how we'll divide that up. And Molly, I think I'll take the first few bullets here and then turn it over to you, if that's all right with you.
Sounds good.
All right. Well, first of all, if you have a term in an incentive compensation plan that you want to enforce, like a stay through March 31st provision, you certainly don't want to get into an argument about whether the employee knew about it. If you want to have any chance at all of getting a court to respect the contractual deal you made with your employee, you want to make sure that you can prove what the deal was and prove that the employee knew it, because judges are really going to be torn about these cases. And if you give them an excuse to make it easy, they'll say, oh, that's easy. You didn't tell your employee the deal, and so you can't enforce the condition. So that's sort of like table stakes, is get a written acknowledgement of the incentive plan. And as we'll talk about in a minute, a lot of incentive plans, mostly I think Barry will talk about, but I'll steal us under just a little bit. A lot of incentive plans are written by salespeople who are steeped in the specifics of their comp plan. They know them backwards and forwards, and they can calculate the incentive comp or the commissions in their sleep. But I think they are not always so good at making it so that ordinary mortals, like lawyers and judges and jurors, can understand what the heck they're talking about. So having someone sign a written acknowledgement of an incentive plan that is incomprehensible or really elliptical and no one can really understand the key terms isn't going to get you there. So you really want to try to make it clear. I try to tell people to write it like you're trying to explain it to a smart 4th grader, a smart 8th grader if you must. But some lawyers, when it gets to math and spreadsheets, only operate at that level anyway. So anyway, a signed written acknowledgement, a written acknowledgement, whether it's signed or not, some way that you can prove that the person knew the deal. Choice of law and choice of venue. Massachusetts now, I think, is as bad as anywhere for an employer in terms of where you don't want to get sued. And one way to not be under the Massachusetts Wage Act is to not have the Massachusetts Wage Act apply to anything that happens because the employee is not in Massachusetts and you're not in Massachusetts. So, if let's say you have a headquarters in Massachusetts, you have employees out elsewhere, make sure you're not putting, Massachusetts choice of law in your agreement, and thereby bringing the Massachusetts Wage Act potentially to bear on a compensation arrangement that might otherwise be under Ohio law. And I don't know much about Ohio law, but I guarantee you it won't be worse than this statute and this court decision. So look at your choice of law, and choice of venue is also important because it could make it less inviting for a Massachusetts lawyer to bring the claim if they have to bring it in another venue. And also, I guess another venue is probably less likely to enforce Massachusetts law in a close case than a Massachusetts court would be. So if you have a way, I don't think that you can say, oh, my Massachusetts salesperson who's spent all their time in Massachusetts selling to Massachusetts customers for a Massachusetts company. I don't think you can just specify Idaho law and Idaho venue and be confident that you'll be out from under the Massachusetts Wage Act. That probably wouldn't work. But you certainly want to look at it to make sure you don't bring yourself into the Massachusetts Wage Act or risk doing so any more than you have to. All right. I'll do one or two more. Arbitration is always useful for situations where you're worried about huge numbers of employees bringing a claim. So if you have a large number of employees all participating in the same incentive comp or annual bonus plan, and you're worried about a class action where everyone brings a claim saying that we were paid late, and so now the claim is for 3 times the amount of the annual bonus that was paid to every single employee who got a bonus. That's potentially a high value claim, and the value is largely because it's a class. A separate and complex subject, but arbitration agreements and/or internal resolution processes can make it harder and sometimes not possible to bring those claims on a class basis. You can at least much of the time, if the employee agrees ahead of time to do so, require them to bring that as a claim on an individual basis in arbitration, and that may be preferable. That may be preferable to you. If you have a bonus plan where you've paid someone 8 days after the bonus was due instead of 7 days after the bonus was due or 6 days after the bonus was due, and you're worried about a ticky-tack class action claim, arbitration might be one way to make that less likely. But that's a complicated, separate topic, so we'll just throw it out there as a placeholder for anyone who wants to explore that further. And then finally, I think it's worth defining what efforts. Am I on your turf, Molly? But anyway, I'll do this one anyway since I started. Sorry. I think it's worth defining what the bonus or the commission is compensating. If it's meant to compensate people for staying, and that's why you're not paying it out until their stay date, then make sure you put that in there. If it's partly to compensate them for sort of farming the account, in the sales context, you have your hunters and your farmers, and the person closes the deal, but there's going to be an ongoing relationship with the client, and you want them to be there to manage that relationship and farm and develop the relationship. And that's part of the reason why you're not going to pay out the commission unless they stay through some future date. Try to put all that in your plan and give the judge the ability to understand why this is fair, and it's not just a trick to not pay people after they've done all the work. There's probably lots of other reasons why people provide incentive compensation and commissions, but if you have a fair reason for all of the terms in your plan, you might try to spell out a little bit what it is you're compensating so that the judge can see that it's fair, and then it's more likely then that the judge would respect the written terms of your plan. So Molly, I'll turn it over to you.
Great, thanks so much, Patrick. So I'll cover these last 2 items here. So the first is we're really recommending considering whether it's possible to shorten the performance periods for various incentive payments. So for example, if your current incentive plan provides an annual bonus or your plan calculates and pays out commissions quarterly, consider whether you can shorten those periods in any way. So for the annual bonus, can you make that monthly, quarterly, even semi-annually? Or for the quarterly commissions, can you make those monthly? And really the benefit of doing that is if there's a dispute over that payment or if it's paid late, anything along those lines, the payment at issue will be smaller, which results in lower potential liability. Really what we're trying to avoid here is the worst case scenario, which would be a dispute over a very large incentive payment in light of Reuter. You could very easily see an annual bonus turning into large 6-figure liability. So essentially it would be helpful to see if you can break down your incentive payments throughout the year as opposed to paying out those large sums at once. In a lot of instances, these are, ingrained practices at companies, and so people are expecting that annual bonus. So it may be difficult to implement something like this, but in the long run, I think, employees could potentially even, like it better, getting those incentive payments on a more frequent basis. So then finally, Patrick actually discussed this a little bit, but a lot of incentive plans have language that require employees or participants in the plan to be employed on the date that the incentive payment is paid. And I can't preface this enough by saying that we really don't know if these provisions are going to be enforceable moving forward. There's case law kind of going both ways. And so all of this, it has to be taken with a grain of salt, because there's no way to make this type of provision in your incentive plan bulletproof. But there are ways to make them hopefully more likely to be enforced. So if your plans do have this type of provision, the reason why we say that they're potentially unenforceable and likely unenforceable on their own is because of a recent decision from the District of Massachusetts. That case is called Israel versus Voya. And so I'm going to talk a little bit about the facts of that case because it is relevant, and it actually pretty much demonstrates the most clear-cut example of why these types of provisions can be problematic. So in that case, the plaintiff was a salesperson and earned commissions on a monthly basis, but the commission plan at issue provided that those commissions would be paid on the third month after the production activity occurred. And it also had a provision saying that the participant had to be actively employed in order to receive that payment. So in that case, the plaintiff resigns and then is not paid the commissions that he had earned in the 3 months preceding his resignation. So ultimately, the court found in that case that 3-month delay was impermissible because his commissions had been earned already on a monthly basis. They were definitely determined. They were due and payable at the end of the month in which they were earned. And the only reason that they weren't paid was because the plan had baked in this, what the court described as arbitrary 3-month waiting period. So the court really thought in that case that to rule otherwise would be to encourage employers to essentially evade the Wage Act by imposing lengthy delays on the payments of commissions. So if there's a waiting period in an incentive plan requiring active employment in order to receive the payment, that's on its own likely not enough. So what can we do here? Again, nothing is bulletproof because these provisions are still risky, but you could consider adding in additional context as to why the payment is being made on a certain date and why the participant must be employed on that date. So for example, if it's an annual incentive payment and it's not paid out until March, okay, well, what's happening in those 3 months in Q1 in the next year? Are you expecting that the participant in the plan is going to be continuing servicing the client that the incentive payment is based on? Do you want that individual to continue working on the account? Is it because there are internal calculations that need to be done in order to calculate what that incentive payment is actually going to be? Even is it because you are wanting to retain that employee and hoping to make this some sort of retention bonus? So there are a lot of things that you can add in, but you really need to make clear why something is being paid when it's being paid in light of Reuter. You want to avoid any opportunity for an employee or a plaintiff to say, my payment was earned as of X date and it wasn't paid until X months later, and I left the company and I wasn't paid it when I was terminated. So being very clear about why that payment is being paid when it is paid and what it is based on is going to be really, really important moving forward. And on that note, I'll hand it over to Barry to talk a little bit more about commissions.
Thank you, Molly. I'm going to talk now specifically, and we can move to the next slide. I'm going to talk specifically about measures that you can take in concrete terms in your commission plans to insulate you from the risk that Patrick and Molly have identified, because there are specific and discrete things that you can do that are going to make you less vulnerable to attack. And the first thing here is a reiteration of a point that I think we've all made, which is that any incentive plan has to be clear and understandable to somebody who's not a salesperson. More specifically, it has to be understandable to a judge and potentially a jury. And I'll put a finer point on something Patrick said earlier. One view of the world is that these cases are hard for judges, but one fact about the world is that some judges are just cynical about these claims. And having been in front of a lot of judges where you have a salesperson who is suing his or her employer for commission, there's a palpable feeling that you get from some judges that there's a belief on their part that the employers in general have their knives out and are looking to short employees. Molly and I had a case in Superior Court a number of years ago where a pretty well-respected Superior Court judge said from the bench, on the record, how is it that when an employee stays with the company always has the money to pay the incentive commission, but as soon as somebody leaves, suddenly the company doesn't have any more money to pay that. And this is a case that we subsequently won on summary judgment. So there's no question that the employer had a good and valid defense, but from the first moment we stepped into that controversy, there was a sense in which the deck was stacked against us. So what do you do with commission plans to make them specific? One is the simple translation of the terminology into words that a smart fourth grader would understand, as Patrick put it. To be more specific about that, the first thing you want to do is look at the terms in your plan and how they are defined. I've seen hundreds of these things, and oftentimes you have key provisions in a plan that have no definition whatsoever, or worse, have contrary definitions, or the same term being used different ways in different parts of the plan. You should make sure that that's not going to happen when a judge is looking at your plan and trying to decide whether it's clear enough to specifically dictate that the plaintiff isn't entitled to what he or she is looking for. Another way in which we oftentimes get tripped up by the terms of commission plans is just their sheer complexity. You might have a given incentive that pertains to a given type of sale that has a performance period that is not coextensive with compensation you might get for a different type of sale. And you just have all of these moving parts in many of these commission plans, which causes two things. One is just natural confusion. And second is that complexity is a natural ingredient for disputes and conflict. People are going to come up with different interpretations of terms that are more complex. And so the first thing you should do, as I said, in reviewing one of these plans is make sure the terms are defined. The last thing you should do in drafting a commission plan is go through it again and see if there's anything you can do to simplify it. Because the simpler it is, the more likely it is to be given effect by anybody who touches it. Second, I want to re-emphasize the importance of having acknowledgments of incentive plans because it's a more acute consideration when you're talking about commissions. Those plans tend to change year by year. They change as a company redefines its targets, resets its quotas, relooks at its market, and we tend to see structural changes to commission plans year to year more than we tend to see that with bonus plans, which tend to be simpler and more static. And so you want an acknowledgement from every participant in every plan every time the terms change, which is typically going to be annually. And especially in light of this stringent liability standard that Molly has described, you need to make sure that that plan is in circulation and acknowledged and accepted by the participants in the plan before the performance period begins. Believe it or not, it's actually fairly common for employers to issue incentive and commission plans only after a quarter or plan year has started. And that very often gives rise to claims from the participants that, hey, I wasn't given due notice of this and the employer is trying to pull a fast one on me. And that's how you quickly find yourselves in the sights of a dispute. The third general thing before we get into specific language that may be useful in this context is not so much about how the plan is drafted, but how it's implemented. I have had a number of commission disputes in which the plaintiff is not saying, hey, the plan says that I'm entitled to this, and the employer did something that was completely not contemplated by that. What we oftentimes see is a plan is rolled out, designed by the top sales executives in a company and put through the paces and distributed out to the participant group. People start performing under it, and then some of those detailed mechanisms in the plan become a distant memory. And you may have sales leadership doing things that are consistent with the design of a plan, but not necessarily consistent with the language of a plan. And that is another way to give yourself a natural dispute, which could become litigation, which could become treble damages. I'll give you an example of that. In some cases, and I've seen this happen a number of times, you may have a provision of your plan that allows sales leadership to adjust how a transaction is treated in some way. For example, if you have a very large order, maybe there would be a cap on the commission that the employee receives for a particular sale or something like that. But then when that eventuality comes to pass, instead of applying the plan strictly in the way that it's written, sales leadership will increase the salesperson's quota instead of decreasing their quota attainment. And there's 100 permutations on that, where you do something that is the logical equivalent of what the plan seems to describe, or is at least consistent with the intent of the plan, but is not consistent with the strict language of the plan. In light of this zero margin for error liability environment, that sort of play in the joints in your commission plan and your operational implementation of it just ceases to exist. You need to make sure that when you're living by this plan over the course of the year, that you're living by the strict terms of that plan and not sort of fudging the margins. So this last major bullet provides a laundry list of terms that you should consider in reviewing your own commission plans. Not every provision I'm going to mention is going to be perfect for every plan. And one thing that is really critical about these commission plans in particular is tailoring it to your business. It is, more than most things, not a one-size-fits-all situation. It is not a form that, for example, lawyers can usefully knock off a template for and just give you. You need to calibrate the terms of that plan to what you are trying to incent. So let's go through a few of those. One that's not on this list, but is kind of obvious, but nonetheless tends to get overlooked, is a clear set of eligibility criteria for plan participants. Who gets to participate in this plan, who doesn't, and what sorts of things might happen to take you out of eligibility as a participant. For example, a promotion or a lateral move, many other things. A performance improvement plan could take you out of eligibility, and you need to make sure that if you're going to impose those sorts of restrictions on eligibility, they're very clearly stated in the plan. The first point noted under these specific provisions goes back to a point that Patrick made that I want to dig into a little more deeply. It is the case, as Patrick said, that most commission plans operate in a way that provides payment for commissions earned in a month or in a quarter, some period of time after that month or quarter is ended. And under the Wage Act, you get 6 days from when a commission is definitely due and payable, definitely determined due and payable, to make that payment out. But as an operational reality, no one does that, or very nearly no one does that. So what sort of things can you inject into a plan that will give you some insulation for a longer period to calculate and pay these things out? One thing that I tend to advise employers to do if they can is provide some description of what's going on between the end of a performance period and the payment of the commissions that are earned for that performance period. What does the company need to do to calculate those commissions and reconcile them with other business information? And that oftentimes is a reconciliation process that really does have some heft to it. It would be difficult or impossible for most employers to do it within 6 days of the end of the pay period. And you may be able to beef that up. For example, if there are provisions of your commission plan that deal with set-offs or chargebacks or different escalations of commissions, as Patrick described earlier, you want to go ahead and state in the timing provisions of your plan as much as you can about why there's a period of time that passes between the end of the performance period and the payment of wages, because that gives you the best chance of convincing a judge that it's not arbitrary, that it's driven by real business practicalities. The second enumerated point there is windfall provisions, which is a favorite of ours, and it is probably the least favorite provision of the plaintiff's bar. The plaintiff's bar would like to tell you that these provisions are just unlawful, and we should back up a little bit to give a little more definition as to what a windfall provision is. They're sometimes called bluebird clauses. I think windfall is the most common term for it, but essentially what we're talking about is a provision in a plan that says, we've put together a script for how you will get paid commissions based on the circumstances we can predict. But life is unpredictable. And so if something that is unforeseen and contrary to the design of the plan occurs, we as the employer reserve the right to treat that transaction in a special way. We reserve the right, for example, not to give you commission for a transaction that you didn't really originate, or we reserve the right to limit commissions where a given transaction has some very unique aspect to it. To provide examples, again, I had one for a major bank many years ago that was based on a salesperson who originated a transaction that was something like $1 billion deposit, but it was in the coffers of the bank for one day because it was part of a class action settlement and was just distributed out into the world after 24 hours. And applying the normal commission provisions of that plan would have generated a commission in the hundreds of thousands of dollars based on nothing but the salesperson picking up the phone and having a 30-second conversation with a lawyer about this deposit. If the people that you're incenting are doing business in an environment that is that pliable, if it's not so scripted that you have clarity as to exactly how orders are going to come in, what they're going to look like, and how profitable they're going to be, you want to consider a windfall provision that will reserve the discretion to depart from the standard provisions of the plan. And at the same time, you don't want to go too far with that, because some windfall provisions would say, we just reserve the right to do whatever we want to do and to treat any transaction however we want it for any reason. Pushed too far, that becomes an argument from the plaintiff's side that the whole plan is illusory. It's not really a contract. It's not a promise of anything. It's just a bunch of puffed up language that the employer presents in order to get people to work harder. So think about the sales that your folks are pursuing. Think about the types of transactions that they can originate, and then tailor your windfall provision to whatever circumstances you don't expect, but you can foresee given the structure of your sales organization. Related to that, it's very helpful to have a provision that delegates interpretive authority of a plan, at least for some employers. And what that looks like is a piece of language that says, if there's any dispute about the terms of this plan or its application to any particular transaction, that dispute will be resolved by this designated person. Usually you would designate that person by title. In some plans, I've seen it designated to a committee, a small group of people. But the point of doing that is to provide an internal dispute resolution mechanism for anything in particular that might be ambiguous about the plan before it gets passed on to a judge. And while the law in this area is still developing and will probably begin to develop more rapidly after Reuter, both windfall provisions and provisions delegating authority to interpret a plan appear to be entirely legal. There are no cases that say that sort of provision just isn't going to fly. So you want to take advantage of those while you can. And the second thing that I would say in that regard is, if you do delegate interpretive authority for a plan provision or for a plan generally, use it so that when a particular circumstance comes up and you have a salesperson challenging the compensation that they've been paid and saying, for example, I should have gotten more commission on this deal, or I should have been given transactional credit for this deal, run it through the person or committee designated under the plan to make a specific determination, and then have that issue in writing so that when you end up in front of a judge, you not only have some plan language that's potentially ambiguous, but you have somebody who's taken a look at that in light of the business considerations that the plan is designed to serve, and hopefully provided at least a succinct, reasoned explanation for why the company is doing what it's doing. That too will give you at least a fighting chance in a wage dispute pertaining to commissions. The next one is fairly straightforward, and it could be a little bit broader than caps, but we see a lot of disputes about caps on earnings. Sales folks will take the position that for some reason the plan terms are ambiguous and a given cap didn't apply. We certainly have cases in which sales folks have said, I wasn't aware of a cap, or it wasn't sufficiently communicated to me. So those things need to be very clear if they're going to be included in a plan. And in the vein of something a little bit more broad than caps, anything that's going to trip someone over a threshold or establish a ceiling for payment of commissions really falls in the same category. So for example, we oftentimes see disputes about accelerators. The first $1 million of widgets you sell, we're going to pay you 2%. And the second $1 million of blue widgets you sell, we're going to pay you a different commission for that. And in the complexity of the plan, folks tend to find ways to create disputes and argue that they have earned more than they were paid. Any provision that changes those accelerators, caps, or other thresholds, you want to make sure is unmistakably clear. Similarly, you want to make sure that it's clear who gets credit for a given sale. I've seen a lot of compensation plans that may assign people territories, for example, but not account for what happens if somebody makes a transactional sale outside their assigned territory, or makes a sale in conjunction with someone who's responsible for another territory. That's all things that need to be battened down in the theme of this webinar. And it's also another example of the sort of thing that can be clarified with a provision that delegates authority to some particular person. If you have a dispute about whether a given person should be given credit for a sale in a given territory, send that to the committee and clear it up. Chargebacks are another thing that need to be looked at closely. They're very common in commission plans. And if there's going to be a withdrawal of credit, anything that decreases the amount of money that a salesperson stands to get paid, that is a lightning rod in a commission plan. That is where you're likely to meet a challenge and where folks are likely to become upset with you. So you need to make sure that those are based on very clear, articulated criteria so that when one of those chargeback scenarios happens, it should be clear even to the salesperson who originated the transaction that a chargeback is going to apply. Lastly, another one that's not on the slide here, but occurred to me as we were getting ready for this webinar, is it's vitally important that every incentive plan you have, but certainly commission plans in particular, have what we call an integration clause. And say that the terms of this plan are as set forth within the four corners of this document, and anything that your supervisor or somebody that you run into at the water cooler may tell you about this plan or your entitlement to commissions under it cannot change the terms of the plan. The written document will govern. Oftentimes that gets overlooked, and you do have sales folks come forward and say, my manager promised me double commission on this sale if I did something in particular. You want to make sure that the written documents foreclose those sorts of arguments from salespeople. That kind of covers our list of the key provisions in your sales plan that you should be looking at. And I think it also just about covers our time. So I think this will end the formal and organized portion of the presentation. And we thank folks for joining us for this part of it and invite you all to hang around. Patrick and Molly and I will be here for another 15 minutes or so and can take questions from the chat about particular issues you may be facing with your incentive and commission plans. And I'll tell you, I'll start the bidding there in terms of the workshop portion of this program with a question that just showed up in the chat a few minutes ago about whether other states have laws like this.